uh, frequently asked questions about the California Constitution, Article 2. How many sections does Article 2 have? It contains 20 sections. What does Article 2 relate to? It relates to voting and direct democracy. Who has political power in California? Section 1 of Article 2 specifies that all political power is inherent in the people, and government is instituted for their protection, security, and benefit, and they have the right to alter or reform it when the public good may require. Who may vote in California? Section 2 provides that a United States citizen, 18 years of age, and a resident in this state may vote. What happens to the votes cast? Section 2.5 specifies that a voter who casts a vote in an election in accordance with the laws of the state is to have that vote counted. What voter laws can the legislature enact? Section 3 provides that the legislature defines residence and provides for registration and free elections. Who cannot vote in California? Section 4 states that the legislature must prohibit improper practices that affect elections and provide for the disqualification of electors while mentally incompetent or imprisoned or on parole for the conviction of a felony. What happens in voter nominated elections? Section 5 provides that a voter nomination primary election is to be conducted to select the candidates for congressional and state elected offices in California, and that all voters may vote at a voter nominated primary election for any candidate for congressional or state elected office without regard to the political party preference that is disclosed by the candidate. The candidates who are the top two vote getters for a congressional or state elected office must, regardless of party preference, compete in the ensuing general election. Which elected offices are nonpartisan? Section 6 states that all judicial, school, county, and city offices, as well as the superintendent of public instruction, are nonpartisan. Is voting secret in California? Section 7 requires that voting be secret. What is the initiative power? Section 8 provides that the initiative is the power of the electors to propose statutes and amendments to the Constitution and to adopt or reject them. What is required for an initiative in California? Section 8 also states that an initiative measure may be proposed by presenting to the Secretary of State a petition that sets forth the text of the proposed statute or an amendment to the Constitution, and that's certified to have been signed by electors equal in number to 5% in the case of a statute and 8% in the case of an amendment to the Constitution of all the votes cast for all the candidates for governor at the last gubernatorial election. What is a referendum? Section 9 provides that the referendum is the power of the electors to approve or reject statutes or parts of statutes, except urgency statutes, statutes calling elections, statutes providing for tax levies, or statutes providing for appropriations for the usual current expenses of the state. What is required for a referendum in California? Section 9 states that a referendum measure may be proposed by presenting to the Secretary of State within 90 days after the enactment date of the statute a petition that's certified to have been signed by the electors equal in number to 5% of the votes for all candidates for governor at the last gubernatorial election. When does an initiative or a referendum take effect? Section 10 states that an initiative, statute, or referendum approved by a majority of voters take effect on the 5th day after the Secretary of State files the statement of the vote for the election at which the measure was voted on. Now, it also provides that the measure may provide that it becomes operative after its effective date. What happens when a referendum is filed? Section 10 specifies that if a referendum petition is filed against a part of a statute, that the remainder of the statute will not be delayed from going into effect. What happens if two or more ballot measures conflict? Then Section 10 states if the provisions of two or more measures approved at the same election conflict with each other, then the provisions of the measure receiving the highest number of affirmative votes prevails over the other. What happens before circulating an initiative or referendum petition? Section 10 also provides that before circulation of an initiative or a referendum petition for signature gathering, A copy is required to be submitted to the Attorney General, who then prepares a title and summary of the initiative or referendum measure. Is an initiative or referendum allowed at the local level? Section 11 states that initiative and referendum powers may be exercised by the electors of each city or county under procedures that the legislature adopts, except when a city has a charter. What types of measures are prohibited from being placed before voters? Section 12 states that no amendment to the Constitution and no statute proposed either by the electors or by the legislature to electors that names any individual to hold an office or names or identifies a private corporation to perform any function or to have any power or duty, and those may not be submitted to the electors or have any effect. What is the recall power? Section 13 specifies that the recall is the power of the electors to remove an elective officer. How is a recall pursued against a state official? Section 14 provides that the recall of a state officer is initiated by delivering to the Secretary of State a petition that alleges the reason for the recall. Note that sufficiency of the reason is not reviewable, and proponents have 160 days to file the signed petitions. What are the voter signature requirements for a recall petition? Section 14 provides that a petition to recall a statewide officer must be signed by electors equal in number to 12% of the last vote for the office, with signatures from each of 5 counties equal in number to 1% of the last vote for the office in that county. And signatures to recall state senators, members of the Assembly, members of the Board of Equalization, and judges of the courts of appeal and trial courts must equal 20% of the last vote for that office. When must a recall election be called? Section 15 specifies that an election to determine whether to recall an officer and to elect a successor must be called by the governor and held not less than 60 days nor more than 80 days from the date of certification. What happens if a majority vote for a recall? Then Section 15 states that if the majority vote is to recall the official, then the officer is removed. And if there is a candidate, the candidate who receives a plurality is the successor to the office. What role does the legislature have in that petition process? Section 16 states that the legislature is required to provide for the circulation, filing, and certification of petitions, the nomination of candidates, and of recall elections. What happens if the governor or the Secretary of State is facing a recall? Section 17 provides that if recall of the governor or Secretary of State is initiated, then the recall duties of that office must be performed by the lieutenant governor or the controller, respectively. What happens if a state officer is not recalled? Section 18 specifies that a state officer who is not recalled must be reimbursed by the state for the officer's recall election expenses that are legally and personally incurred. How often can an official be subject to a recall? Section 18 provides that another recall may not be initiated against that officer until 6 months after the previous recall election. Are local officials subject to recall? Section 19 requires the legislature to provide for the recall of local officers. However, this section of the Constitution does not affect counties and cities whose charters already provide for the recall. And finally, when do terms of office begin in this state? Section 20 specifies the terms of elected office provided for by the Constitution other than the members of the legislature, and it says that those terms of other elected officers commence on the Monday after January 1 following their election.